Good evening. My name is Melissa Jenkins, and I'm doing case briefing for the Adler Savoy Plaza Inc. The facts are as follows. Mr. and Mrs. Adler visited the Savoy Plaza in May of 1946 in New York City. The couple arrived to only discover that their reservation was actually in fact booked for the following day, but were advised by the hotel that there was possibility that they could accommodate them. So while they waited to see if they could be accommodated, the Adlers stayed on site and left their luggage with the bellman in the lobby. They, throughout the night, checked back and unfortunately were advised that they would be then, in fact, have to stay at a different property nearby. But Miss Adler decided to keep her luggage on site, some of her luggage, in fact, one large suitcase containing over $20,000 worth of jewelry and $3,300 in personal assets, and then a couple small others. So basically, she decides to leave her luggage, has a conversation supposedly with the bellman stating that there is valuables, that she should secure them in envelopes into a safe. Bellman then replies saying that not necessary, that the whole suitcase could go into a vault. Needless to say, they stayed at another hotel, came back the next day, requested for their bags to be then delivered to their room, and they discovered that the large suitcase was missing, the one that included all of the personal belongings and jewelry. It was then said that the hotel manager the night before delivered it to an imposter. So the case facts, those are the case facts. The issue that the court was facing was whether the defendant could be held liable, the Savoy Plaza would be held liable for the sections 200 and 201 of the general business law. The defendant argued their liability over the loss of jewelry that the plaintiff failed to deposit correctly and not put it into a safe, as well as liability of personal property delivered. With that, Section 200, the rules, Section 200 exempts hotel from liability from the loss of guest jewelry if the guest fails to deposit it correctly in the safe provided from the hotel. For a hotel to be liable for the guest items, this guest must provide it directly to the hotel for safekeeping, which did not seem to happen, as this conversation with the bellman may or may have not occurred. Section 201 also limits the hotel's liability for the loss of personal property other than jewelry delivered for storage elsewhere in the hotel. Unless a value exceeding $100 is stated at the time of delivery, the hotel's liability is capped then at the $100. Application. The court applied the statutory defenses based on the plaintiff's actions. The court found the plaintiff had not deposited her jewelry in the hotel safe, so that the hotel was then not liable for this loss. The plaintiff's failure to comply with the requirement hindered her claim under this section. Under 201 section, the liability is limited to $100 based on the fact that the property was lost from a check room and not the actual guest room. So because there was no value stated and the luggage was stored and not secured in her suite at the time of the missing items, that would mean that the defendant believed that under this law they were not liable in excess over the 100. The conclusion basically came in favor of the jury favored the verdict to the plaintiff for $2,000. A new trial was requested by the defendants under the statutory defenses under those sections, emphasizing again that they were not liable because of her negligence to properly secure her jewelry. Ultimately, they requested for the verdict to be reduced to the 100, and it was denied. So based on those facts, I actually will argue and agree with the defendants in this case. The plaintiff had a duty to secure belongings directly with the hotel and just failed to not do so. The conversation with the bellman, he claims did not happen. So we would argue that fact. Although they could have been held negligent to delivering the suitcases, the fact that she did not hold the suitcases, we have no evidence that the suitcases were in fact a real suitcase. So there's no proof that the suitcase exists. So basically, I would believe that the defendant acted rightfully in requesting the new trial, and unfortunately, for that reduced amount, and unfortunately did not succeed. Thank you.